Good evening, everybody, and welcome to the second part of our focus on the transition to adulthood. It's our summer focus this year. It's something new that we were trying. So we're very excited to have Linda Hunter Suzman and Karen Marie Thompson here to speak. So I'm going to introduce them in just a moment. There's a couple of people waiting outside, so we'll let them filter in. Quick plug for next month's lecture, when we're going to have Tammy Mitchell, who's the program director at the Alyssa Burnett Adult Center, come, and she's going to be speaking with Gary Stobie and Therese Fahazadeh, who are both over at the Adult Autism Clinic at the University of Washington. So, and they're going to be speaking about this idea of lifelong learning and having a meaningful life. So those are going to be, that would be a great one to make sure to come to. So I'll introduce Linda first. Linda is a financial services professional with Mass Mutual Financial Group with 23 years of experience in assisting business owners and families with their life, disability income, and long-term care insurance needs. As a special care planner, she works closely with legal, accounting, and banking professionals to encourage special needs families to create financial and legal plans for the present and the future. She graduated from the University of Washington with a degree in international political economy, spent several years in insurance management and banking. Okay, so I just got back from the East Coast. I'm originally from Rhode Island, so if you're hearing my East Coast accent a little bit, I'm noticing like I'm saying University of Washington in a different way than I might. So, and Karen, thanks for coming also. Karen is a partner in the law firm of Thompson and Howell. She graduated from the UW School of Law in 1977. Her practice focuses on elder and disability law, representing individuals and professionals in complex guardianships, probates, long-term care planning, and drafting and administering special needs trusts. She also acts as a mediator. She has been selected as one of the city's top lawyers by Seattle Magazine and a super lawyer by Washington Law and Politics for several years. She is a frequent speaker at CLE's law school classes and conferences on guardianships, ethical issues in elder law, and special needs trusts. Thanks so much for coming, and have a good evening. Thanks, Linda.
Thanks, Jim, for that gracious introduction. It's my great pleasure to be here chatting with you about special needs care. Let me see if I can do this technical stuff here. The idea behind life care planning is to examine your financial strategies, access vital information, and meet specialists who will work with you and your professional advisors, like your banker, accountant, financial professional, lawyer, social workers. I see we have one social worker, and healthcare providers to create a life plan for your special needs child, especially as they move into adulthood. And this requires a team approach or a holistic approach. The main goal is to balance the emotional and financial needs of the child with your financial goals and needs for your family and also your retirement. And the dollars have to go much further. One thing you should know about me that wasn't on the introduction is I'm also a special needs parent. My story is that I have a 24-year-old young man who is my son, and he has not only, he's on the autism spectrum, but he also has ADHD and oppositional defiance disorder. I would say that's the stressful trifecta. And fortunately for me, he has a good sense of humor. But we have had our ups and downs. He's quite intelligent, like most children, and probably will do pretty well in the end, but it's very uneven development. So that's a little bit about me. The next slide is one that we have to tell you about, which is a disclosure. Don't take anything I say as absolute tax advice. Check with your attorney and your tax accountant. That's basically what it's about. Let's see if we can. What is a chartered special needs consultant? You may be familiar with CLU or CFP, Certified Financial Planner. Those are designations for financial professionals through the American College. And the American College felt that they needed a new designation that really responded to special needs families called Chartered Special Needs Consultant. So you'll notice that that's on my business card. The program features 120 academic hours and exams to qualify. But now that we've been introduced, I'd like to know a little bit more about you. So how many of you are parents with special needs children? Almost all. Okay. I just want you to know you're my heroes, and I have high regard for you because I know the struggles that you probably are going through or have been through. How many of you are therapists and educators? Anybody? Oh, good. You're also my hero because you help us do our jobs. Then let me ask you, how many of your children are under 12? Okay, I know I met you. You have a 3-year-old, right? Okay, and how many over 12? Young adults? Most of you. Okay, great. Thank you so much. One last question. What keeps you up at night when you think of your child's future? Let's take someone with an older child. Anybody? What keeps you up at night? Yes.
How will they live when I am gone?
Perfect. Yeah. Yeah, that's the thing that keeps me up at night. So for me and many of the other families that I speak to, there are two main questions. Who will care for my child when I'm gone, right? And then, will my child have enough money and support to live the life that I'd like them to live? So what makes me sleepless in Seattle is knowing that our son will probably outlive my husband and I. We won't be around to guide him financially, socially, and more importantly, emotionally. And that is a huge burden on all of us. It's very stressful. So let's define some of the issues. Many of our children on the spectrum will be employment challenged. And that means that their social challenges and learning differences may prevent them from full employment. And our mission as parents is to prepare them for a neurotypical world that really isn't ready for them. Unfortunately, they're not prepared to receive them. And I recently met a young man who came to our agency for a job, and he had a 4-year degree in accounting, which I thought was very impressive. He could only get seasonal tax work, and he dreams about sharing an apartment with roommates, and he was looking for a job for $15 an hour. He's very capable. That's his dream. But many of our young adults on the spectrum may not be able to have full employment, and that's just the reality right now. And many of us are working hard with, and I wish I had more time for this, working with companies to try and get our children to be employable, to have them be accepted in the workplace. We want our children to lead full, productive, and purposeful lives. That's what I would like for my son, and I'm sure that's what you would really like for your children. But parents are stressed out both emotionally and financially after years of providing physical and academic therapy. And now they're facing 3 major challenges: planning for their own retirement, planning for the long-term care and support of their young adult who may have challenges, and then finally, some of us have had care and support needed to provide care and support to a parent that's aging. So to me, that is like a triple dose of stress. So what do? We make a plan. Finally, if you're fortunate to have a caring, loving sibling to help your child, we don't, our child is a single child, then that might be helpful. They too will be impacted by enormous responsibility of lifetime care for their brother or sister. Let me give you an example. One of my clients is a young woman. She's in her, I think, 30. She has 3 young children, one with a learning disability. She's responsible for her older sister who's on the spectrum when her parents die. They've bought a rental house next to theirs so she can live in it, but they haven't made any specific plans. They have a will, but they haven't updated it. They have no special needs trust, and she is getting government help. So now she's begun to date. She's been interested in dating, which terrifies my friend and my client. So these are some of the situations that siblings will face with their families. Easter Seals and MassMutual have funded a 20-minute video about special needs family and challenges that speak to the problems of siblings and even the siblings' spouses, the problems that they'll face in the future with their, in anticipation of their brother's lifetime care. It was too lengthy to show this evening, but I'll be happy to show it to any group that wants to see it with a discussion afterward. I just think it's so important, and it is a real family, and it really just, I think, exemplifies the real issues at hand. So, let's see if we can get this to work. Let's go back. Life care plan. To mitigate some of the anxiety that we're facing as parents, we recommend that you develop a life care plan. And this evening, we're going to explore the components of a life care plan and some of the misconceptions. Most of us don't plan to fail, we just fail to plan. So, what is a life care plan? It's a plan. What we're trying to do is create a roadmap with flexibility that takes into consideration the individual person, their needs, priorities, goals, and strategies, which, by the way, change every year. For example, are they able to handle money, their own money? They now have special credit cards that have spending limits and can track specific expenditures even for trustees. So there's many things out there, many supportive items that one can purchase or participate in that would help. For example, I'll use a personal example. When my son turned 18, we had a joint family meeting with our attorney, and we wanted to explain our will, our health directives, our trust arrangement, and how a power of attorney might help him in terms of signing contracts before he was ready, because our children are vulnerable. Even very intelligent children on the spectrum or young adults can be very vulnerable. So we also let him know, though, that the training wheels would come off once he had demonstrated financial capability. We're still waiting. He's 24. We're still waiting. We're working on it. Our children will change and mature, and so I would think that Karen, our resident attorney, would also agree with me that flexibility is very important in the plan, in developing a life care plan. So let's look at the misconceptions. I love this one. It's not affordable. There's so many things that you can do to help your child have a life care plan. But many families are just stopped immediately because they think they can't afford estate and special needs planning. Some special needs planners do charge a fee. I don't. I haven't yet. Trust can begin for as little as $1,500, which is the equivalent of 1 latte per day per year. Actually, lattes have gone up, so I don't know, maybe it buys less. The point being that obviously if they're more complicated, and Karen can address this, they cost more. But the main thing is don't procrastinate. Financial planning does not have to be expensive. And furthermore, how can you fund a trust if you decide on a special needs trust, or any trust for that matter? Grandparents, aunts, family members, they can help fund a trust with cash and investments, or at least a less expensive option can be life insurance. A 38-year-old male in good health can get a 20-year level term policy for $1 million for $117 a month, equivalent to 1 latte per day. So a lot of times there's lots we can do with not very much money. What we did for our son is we did something called an ILET, which is an irrevocable life insurance trust. What we did was purchase a life insurance policy that's owned, paid for, and benefits the trust. You can use the gift tax exclusion up to $14,000. When parents do dedicate a life insurance policy, they can alleviate the need to invade their retirement funds. So this can be a critical part of their life care plan, but it's not the only part. Excuse me. All people need a will, a health directive, but special needs families need to work with a special needs attorney, someone that specializes, like Karen, for example, because the legal language and beneficiary arrangements will be different. If your child qualifies for government benefits because they're unable to work, parents should consider a special needs trust. This will help them provide extra money over and above government funds. They're only allowed to have $2,000, as many of you already know, and the government funds are to be used only for food and shelter. Karen will address this in more detail. When children are on the spectrum, you don't know whether or not they're going to qualify for government funds. Right now I have a son that doesn't work, but that doesn't necessarily mean he's not capable or whether the government will determine whether he's eligible for government Social Security. And that's a real challenge. But the other thing, I don't know, can't make you a legal recommendation, but I really feel that most of us, whether we do a special needs trust or not, should at least consider a trust. And that can be a transitional trust or a trigger trust that can morph into a special needs trust. But not planning, writing no wills, or leaving guardianship up to the courts can be a parent's worst nightmare. If parents have a plan in place, a will, and a trust that's properly funded for the future, the burden on the entire family is lifted. And I think siblings have a more positive attitude in caring for their brother and sister. And I always recommend that parents try to be somewhat equitable with the disposition of their property as for the siblings as well as the special needs child, so they will not feel left out. They need to feel like they have resources to help their brother or sister, but it would also be nice if there was a little bit left for them as well. Let's go to slide. Here are the components of a life care plan. The best advice I ever got from a special needs attorney, the first one we worked with, was plan for the worst and hope for the best. What forced us to go get our first will was a bout with breast cancer that I had in 2000, which came as a complete surprise. So my son had a neurologist, the dog got hit, he had a neurologist, and I had an oncologist. And it was a little crazy at our house, I'll be honest. But what we did is we were fortunate in that someone had referred us to a special needs attorney, and we started the process. So personal planning. The first thing you want to do when you get started is to go through your financial junk drawer. I bet you some of us have those. You know, that's where we stash all of the receipts, and then tax time comes along and we have to look through all of them. So many financial planners are saying put your own oxygen mask on first and then your child's. What we try to help you do is make a financial inventory. We help you get organized, and I recommend that if you can, use Quicken or Mint or some kind of financial software to track your expenses, because we're looking for extra money to help you fund your plan. So we have financial tools that can assist you in organizing assets, liabilities, insurance, retirement funds, and specifically we review your employee group benefits, which can be a great source of coverage for you that probably cost you nothing or very little. We look at your medical coverage, savings, investments, real estate, and we try to analyze as you look towards retirement whether it's tax deferred, tax free, or possibly tax deductible. In some cases, some long-term care coverage is tax deductible, a portion of it, depending on your modified adjusted gross income, MAGI. We have Social Security software tools that help people decide when they should go ahead and apply for Social Security retirement funds. And most of you know that if you have a divorce, if you've been married 10 years, you can collect on your spouse, your divorced spouse's Social Security. There's a lot of things about Social Security that would be important for you to know. One thing you can do immediately for yourselves right now is to, not right this minute, but maybe after this talk, you can get on the socialsecurity.gov website and create a personalized statement, which will tell you, given your earnings record, whether you would qualify for disability from the government for yourself, and possibly what your monthly retirement dollar amount would be, depending on the age you select. So there's age 62, 66, 70, and you should know that every year that you wait, you get 8% more. That's important. That could be an important amount. So if you don't qualify for disability, and many times a special need parent has stayed home and there's an enormous gap between their earnings, they may not qualify for disability income for themselves. And that's when it becomes important to look at your group employee benefit package, or perhaps think about individual coverage. Because when your income stops, everything stops. So then you start planning. Then to plan for your child, you'll want to consider all the items as we begin to create a life care plan. And I don't have all the answers, but we work with a lot of professionals that do, and it has to be a team effort. When you select a guardian, and this is something that Karen's going to go into a little more detail about, it's probably one of the most difficult decisions you can make. What we did is we chose 4 trustees, all younger than we are. That's a good idea. These are people that know our son and have financial capability to guide him. This is this can be extremely delicate in cases of divorce. I have a dear friend who is a banker. She's very capable. She's made lots of investments, but her divorced husband, who's the father of her son, who's 32 years old in a group home, the reason they got a divorce is because he couldn't handle money. So he is the last person that she wants to have as a trustee or a guardian. So she had a very dear friend, and she was counting on her, and unfortunately she died last year of cancer. So what you need to do, and Karen will address this, is there may be a need for more than one, perhaps almost a committee, or perhaps a professional trustee, and she'll cover that. We'll also talk about a letter of intent in more detail in the next slides. But finally, a special needs trust to manage resources, protect government benefits, and provide supplemental funds, because the government provides fairly limited funds. Your child or young adult may only have, as you know, $2,000 in assets to qualify. There's also the gift card problem. And I'll just mention this briefly because I know Karen knows a lot more about this than I do. But if your child receives government funds and they get a gift card, remember the government funds are for food or shelter. It's considered unearned income. A gift card is considered unearned income. So if they get a QFC card for food, that could be a problem, and that could actually subtract from their benefit. It could, the worst case scenario is that it's a large gift and they lose their medical coverage. That's more important even. So what are the 10 comprehensive life care planning steps? Well, I would say make a plan and reduce your stress. The first thing we do is address primary issues. What are the issues that your child is having? Are they able to manage money, or do they feel very uncomfortable, like my son? My son won't even pay for things in the grocery store. And we've been working with him for 24 years. We're trying. But he will use his credit card. Yay. So we feel like we've made a little progress. Number 2, we create life care plan vision. That is really up to you and the vision you have for your child's life in the future. Choosing a guardian and caregiver is very important, as we just spoke about. Identifying financial resources. The whole idea here is to make the most of the funds that you have. And then we do prepare for life costs. We try to estimate the future need of your child in dollar terms, which isn't easy, but we can try to make at least a best guess. We do have software to do that. Preparing a letter of intent, which, by the way, costs you nothing. That's not a legal instrument by any means, but it's extremely useful to the courts and to your family and whoever takes over the care of your child. So preparing legal wills, trusts, medical directives, healthcare proxies, and powers of attorney. Then review the need for a special needs trust. Very important, fund the plan if you can. You know, we do a lot of business succession planning in my business and for business owners, and it's very important if the business owner really wants to sell the business that there's funds for the person to buy it. But funding is really important when you have this plan, this glorious plan, but your family and your siblings will really thank you if it can be funded. Then I would suggest holding a family meeting so everyone's on the same page and has a coordinated effort. And they'll also feel a sense of participation and responsibility in helping. And then review your life care plan annually, once a year, because our children change every year. On the life care planning pyramid, the reason I wanted to show you this is in the center, there's traditional planning, and then there are the extra steps on the side for life care planning. So while you're planning for your own protection and emergency reserves and all of that stuff, retirement and perhaps education for your other children, you're also having to think long-term about supplementing perhaps lifetime support. This is a typical fact finder for special needs families to complete, which is a little different than a regular fact finder. We have so many fact finders in our business, but this is a special one, and it really addresses the expenses for your child in particular. And this, this slide, Financial Planning 101. When you're looking at your own coverage, we look at protection first, because that sort of drives everything. But a lot of times we can look at your deductibles on your auto insurance, your homeowner's insurance, and perhaps we can just squeeze a little bit of money out of that area so that you could actually fund perhaps life insurance or some other annuity or some funding instrument. And current emergency funds, we recommend 3 to 6 months. Frankly, I think that's just so low. If you're on commission or you have a sales with bonus type of position, you should really have a year in the bank, but 3 to 6 months at least. Always better to have more. Then we look at retirement planning and finally legacy and gift planning if there's any money left. Letters of intent. I actually sent you a letter of intent. I think you have that in the handout. And this is like a little CD, which is fillable. Although it says Mass Mutual all over it, don't let that stop you. It works. It's just, the idea is it's not a legal document, but it's really helpful to the courts. It's something that you can do tomorrow, and it doesn't cost you anything. But it could be very critical to your child's care, future care. You record your child's current situation as well as your future goals for them. It needs to be updated on an annual basis if you can, and I always recommend people do that on their children's birthday, near their children's birthday. Why should we have a letter of intent? Well, if you died tomorrow, and we hope you're all going to be living, but if you died tomorrow, you'd be able to provide the caregiver with explicit and specific instructions about your special needs child. How many of you have children that have food preferences or sleep habits, or they like to do certain activities? They wouldn't ever do anything? Anyone? Right. So I think one of the things, so you have the template. I would definitely encourage you to fill it out. I also recommend that you use a paper file for this information, along with your medical records of your children, because sometimes people don't know your password. This is a real problem in estate planning. I'm sure Karen will agree with me, digital assets. This information could provide some routine and comfort to your child in case of their demise. So on the diagnosis, let's see, I can make that work. Yeah, one of the things that this form has is a place to put your diagnosis. I know there's usually multiple diagnoses with autism. Medications that the child is currently using, this is why it's so important to update it annually. Their doctors that they're using are health professionals, whether they have allergies, do they use a naturopath, where are the medical records kept? That would be a really good thing to know. Living arrangements. Will your child live with you? And what about when you're no longer there? What's your plan? It's really important, even if that never happens, but at some point, of course, it will. We also want to tell the caregiver about activities that they enjoy, their strengths, their weaknesses. For example, my son will not eat meat, but he'll eat bacon. Just a little known fact. Who would ever know that? He can't stand loud noises. He likes computer games. In fact, he likes them so much that we wish he'd play a lot less. Education and work history can be listed. Choice of your caregiver or guardian can also be listed. Here is the document itself. The general information, it begins with general information about the parents, siblings, guardians. You know what, I would put more than less. I would put their social security numbers. I'd put everything that you think would be important to know if you weren't around. The next slide shows medical history, housing plans, daily living skills, routines. Many of our children are extremely capable. They're going to live independent lives. Maybe they'll have a little oversight. It's such a wide range, but it's so important to just get it down on paper. In fact, have your child help you with it. That would be a really good thing. To sit down and say, you know, in case something ever happens to me, I want you to know we've got this document that we're preparing together. This slide talks about education, religious preference, and as I mentioned, add as much detail as you want. This is a guide to knowing your child. Finally, services and benefits, any gaps you feel that the child might need help with, or the young adult. Monthly expenses, extremely important, and financial changes if the parents die. Now, one of the last things that I'm going to talk about is ABLE accounts. I know you're all very interested to know the definition, or ABLE stands for Achieving a Better Life Experience. It's a federal law authorizing states to offer a tax-favored account for people with disabilities who became disabled before the age of 26. This went into law in December 2014. We're all very excited about it. It's very similar to a 529 tax-favored account. And the purpose is to help families save and pay for disability-related expenses. The owner and beneficiary is actually the disabled person, or the I hate the word disabled, I'll be honest. I like the word challenged. There would be tax-free distributions. The maximum contribution is up to $14,000 annual tax gift exclusion, but more to the point, it's a good idea in theory. However, I went to a North Carolina conference on special needs, and all the attorneys, there were 3 or 4 lectures, they were all confused about the regulations. So there's some confusion about the special rules and limits in conjunction with government funding or government benefits. And so June 19th, the proposed guidelines are to be determined. We need the final regulations before proceeding. So I would proceed with caution. They all seem to think we should wait a little bit until we get the final regulations. And to know the exact rules. In conclusion, I hope that we've been able to provide you with some ideas about a life care plan, not only for your special needs child, but for your entire family. Creating a life plan, recording a letter of intent, reviewing your legal documents, your financial plans, and perhaps implementing a trust if you need one with funding will be the most loving gift you can ever give to your child. It's also the most loving gift you can give to your family and yourself. And then we can all sleep better. I think the last thing I have is this quote, because I think the most compassionate and beautiful people I've had the pleasure of meeting are special needs parents and educators, because they go above and beyond for all of their children. Thank you.
Thank you. Linda's done a great job of giving you an overview of what's involved in life care planning when you are parents of a child with special needs, as well as having other children in your family. What I'm going to do is hone in on special needs trusts specifically for this. Linda's comment about her attorney telling her, and we must have gone to the same school, plan for the worst and hope for the best. I mean, I'm telling my clients all the time that attorneys are trained to think in worst case scenarios. Special needs trusts are used to allow people with disabilities to have a pot of money, if you will, that's in a trust, and at the same time continue their eligibility for SSI or for Medicaid. SSI, if for those who don't know, it is the program that the federal government has that provides income for people whose disabilities are severe enough that they're unable to work, and they have never really had much of a work history. Now, this is where the plan for the worst and hope for the best comes in, because with a special needs trust, if you set that up for your child now, let's say your child is 8, 10, 12, and you're thinking, we don't know. We don't know yet what the future is going to look like. We don't know if they're going to be employable or able to work. By setting up that trust, that is, for one thing, can be changed as time goes on. You may or may not need it in the future, but it creates the most options possible for your child's life. I learned this the hard way in that, as a young attorney, when I was relatively new to my practice, I was working with a family with a special needs child, setting up a special needs trust, and as the time came closer to sign the will, I could tell the father was angrier and angrier with me, and it suddenly dawned on me that by setting up a special needs trust, somehow he was thinking that I was saying, or that he was saying as well, my child will never work. And I was explaining to him, we can change this at any time. This just creates the most options until we have a better feel and a better understanding of what your child is capable of doing. Linda mentioned earlier that people with disabilities who are unemployed that could qualify for Medicaid and SSI, Supplemental Security Income, cannot have more than $2,000 cash in their own names. If they do, then they will not be eligible for those programs. So to make funds available to assist them, to help them, the government has allowed and has specifically created the possibility through a law passed in 1993 to create trusts, special needs trusts that have particular kind of language that will allow them to be eligible for SSI and Medicaid, as well as be beneficiaries of a special needs trust. We're going to get into, there's two kinds under the statutes of special needs trust, what's called a first-party trust and a third-party trust. There is no second-party trust, and why they chose to name it that way, I don't know, but we'll get into that in a little bit. Absolutely. I was going to say, feel free to ask questions as we go, because you're going to have to bear with me.
The able thing that we just talked about at the end, would that count against the 2,000 TBD?
The question was, will the ABLE accounts count against the 2,000? You know, I think theoretically it should not, but my own view, and I share this with Linda's, is don't be doing anything with ABLE accounts until the regulations are in place. Each state has, as I understand it, the ability to pass their own regulations for how those accounts are going to be implemented, and Washington hasn't passed theirs yet. So I would just hold off on that. It raises a lot more questions that have yet to be answered with that. What a special needs trust can do, if a person is eligible for SSI and or Medicaid, is also to provide money then to supplement those benefits. Money that can be used then to take them on vacations, to take them on trips, to visit relatives, to buy sports equipment, to supplement physical therapies, other kinds of therapies, educational tools, all sorts of things. I mean, it can be as broad and as specific as the needs of that particular individual. This is also, too, where the letter of intent that Linda was describing and spent some time on really comes into play, because the normal, usual trust document will say something like, these monies are here to supplement the money that they're eligible to receive because of their disability. The trustee has absolute discretion. They can use it for a variety of things, and there'll be these sorts of general statements. But you usually don't, in a trust, put in all kinds of things like, my child only likes bacon, or we would really prefer a quiet environment, or, that level of detail. This is where that letter of intent can be of enormous benefit to those people who are administering the trust. Absolutely. The question is, where does the money come from that are covering the day-to-day living expenses?
Is that in a separate trust?
Okay, you put that in a separate trust or what? The way the trust is set up, it presumes that there will be eligibility for SSI, which is there by the SSI regulations to cover food and shelter. Now, often the trusts we draft have paragraphs in them that say if the person is not eligible or is not receiving SSI, it's totally appropriate to use the money for basic living expenses. Yes, question in the back.
So it seems like you're playing kind of the money shift game of how to be able to save for them while not disqualifying them from SSI and disability.
The question is, it seems like you're playing the money-saving game to figure out a way to have, and I'm going to paraphrase a little bit, qualify them for SSI and at the same time have funds available to cover expenses and needs over and above what SSI covers. Is that a fair?
Yeah.
Yes. Yes, that's exactly what you're doing with the Special Needs Trust. Because in case people don't know, SSI provides the handsome sum of about $760 per month per person. And if you are trying to live on that, that's not going to go very far. Another question.
Yeah, so if your child doesn't qualify for SSI, do you still need a special needs trust?
If your child doesn't qualify for SSI, do you still need a special needs trust? I'm not going to be able to get really specific with your advice here. If your child is got some kinds of challenges with managing money, I would strongly encourage you to consider a trust. It may not be a special needs trust per se, but I would really go through that with whomever's assisting you with your estate planning. You might, depending on where your child is at and what you think their needs are, you might want to create a special needs trust that also has language in it that allows trust funds to be used and outlines the use of those funds in the event that they are not on government benefits. And if they do, for some reason, need them or qualify for them, the trustee shifts its approach, his or her approach in managing that.
That's exactly what we do.
Linda's comment was that that's exactly what she did in her trust. I'm happy to repeat things at the request of the moderator because they're taping this and it doesn't get taped if there's questions. Yes?
Presently, I know.
Hey.
Talk to you later.
Okay.
My son is over 26,
Mm-hmm.
and he doesn't get SSI, but at present, even though he lives at home, I am virtually charging him rent. He will owe me money whenever he ever gets a job, but he's presently getting he has an EBT card. He's on Apple Health to get his health insurance because he has several medical problems, and he has a disabled Metro Pass. As we are working through DVR, Department of Vocational Rehabilitation right now.
Okay, what the person in the audience spoke to was a variety of benefits that her son is receiving while not getting SSI, but he's receiving a number of other benefits, some at least of which are based upon having minimal income, right. In his case, he has no income. But that's another factor to consider. It's not just SSI and Medicaid. SSI criteria and eligibility for SSI is also used in our state for eligibility for other kinds of programs and services, some of which you cannot purchase on the private market, no matter how wealthy you are. Let's go ahead and talk a little more about establishing special needs trusts. Who can do that? I mean, you can do that. Anyone who cares to do that, who wants to benefit a person with disabilities, they can create a special needs trust. And you can do it in two ways. You can create a trust that's in your will that will not go into effect until you pass away or until the second of the parents pass away. Or you can create a trust that is funded now with maybe a small amount of money, and it's there so that other family members, grandma, grandpa, aunts, uncles, friends, can have some place to direct what they want to leave to your child too. You need to remember that the $2,000 cap is across the board. You don't want to make your child beneficiary of your life insurance policy. You don't want grandma to make a very generous gift of $25,000 to your child along with all the other grandchildren. You don't want the aunt and uncle. I mean, it's everybody. And so if you have an idea that there's anyone who's potentially interested, and this isn't necessarily the easiest conversation. Hey, you thinking about leaving money to my child? Well, then in terms of people need to understand the generosity can also be harmful unless it's done correctly and helpfully. In terms of establishing a special needs trust, what it can do then is provides a means to coordinate available resources, ensures the continuity of government benefits, provides a basis to supplement life needs, improve quality of life. And in your trust, you can say, when my son or daughter passes away, if there's anything left in the trust, I'd like it to go to, and you name who it is. And you can also be very clear in the trust that when the trustee's making distributions, the trustee doesn't have to keep in mind that there's remainder beneficiaries. The primary goal is to take care of your child. If there happens to be money left over, great. But if there isn't, that's not going to be, the trustee won't be found in fault for having done that. And then how does the trust work? It stipulates how the money contributed to the trust is to be dispersed for the beneficiary. And keep in mind that because of the way SSI applies its rules, the beneficiary, A, does not control the disbursements from the trust. B, the most of the disbursements should be for third-party providers. You do not give the beneficiary an allowance once a month. They're going to get X number of dollars. That will only result in reducing how much they get from SSI, because SSI will view that as steady monthly income. If you're in another state, you need to go to an attorney familiar with the laws of that state, because one of the things about having 50 states and states' rights is that each state can have some variation of the Medicaid program. So you want to be sure that the trust works for the state in which your child is residing. Naming the trustee, this is really critical, and it's becoming increasingly so. And I spend some time talking with my clients about this. Please don't automatically assume that a son or daughter or family member is going to be the trustee. You need to think about a number of things, including, is the person who is trustee or going to be trustee willing to spend the time to stay on top of the changes in SSI and Medicaid regulations? I kid you not, Medicaid regulations change every 6 months, literally. And SSI changes its interpretations of how special needs trusts can be administered. Being cynically speaking, initially when special needs trusts were set up, SSI and Social Security would look at the way they were created to see if there was a way of saying, oh, no, this isn't a special needs trust, this is a regular trust, and therefore you're no longer qualified for SSI. Now they look at how the trust is administered and the distributions that are made from the trust. And they will literally do spot checks. I've had clients call up and say, whoa, SSI just asked for records for the last 2 years. Can they do that? Well, yes, they can in terms of accounting. And I have had situations, and I'm working on one now, where the trustee was a good friend of the beneficiary and really messed it up, and has resulted in the beneficiary no longer getting SSI. And that princely sum is not so huge, but the Medicaid that goes along with it is of huge consequence to this individual. And so you really want to know that it's someone who is willing to take the time to stay on top of things, someone who has fiscal responsibility, and someone who is willing to spend the time acting as trustee. It may make sense to include a provision that they can actually charge a fee for what they do to make sure that they get that they're involved and do their job. I was telling Linda this, and she suggested I repeat it. I was working with some clients a while ago who had a child that they wanted their daughter to be the trustee of the trust. And I said, how is she with managing money? Oh, terrible. And I said, and what does she do? Well, she's a teacher and lives in another town, but we have a house next to ours, and we have our son living there, so when we die, she'll move into our house. And I said, well, how's that going to work if she's living in another town and working there? Oh, it'll work. And I was thinking, whoa, I mean, the parents had it worked out, but it didn't look like the daughter was a good choice just from the fiscal approach, and never mind that she had her own life. I mean, she was a single parent. She was working in another city as a teacher. You really need to think through carefully the assumptions about who's going to be trustee, and I think it's important to think through, too, the assumption of whether a son or daughter of the sibling will do it. I met with some clients recently, and they were talking about their other children, and as soon as one turned 21, they were going to make her the trustee. And I said, well, what is she doing? Well, she's in the middle of college, halfway across the country. And then they also talked about how resentful the other children are in terms of the amount of time that their child with disabilities took. And I thought, whoa, this is not... I started trying to suggest that they might think about somebody else, at least temporarily, being trustee, because it didn't sound like she was going to be very available. Really need to think carefully who that trustee is going to be. The next comment on this slide, which is also very helpful, is that the trustee not only has to follow the terms of the trust, but the trustee has a fiduciary duty to the beneficiary, meaning that they need to handle things properly. They need to do it prudently. They cannot self-serve. They can't decide, well, I'll be the caregiver. I'll pay myself out of, and the trust has a lot of money. I mean, they've got to be really clearly understand what their legal obligations are under this. A first-party trust, I'm only going to spend a little bit of time on that. Let's say wealthy Aunt so-and-so does, in fact, leave your child a huge amount of money. There are procedures in our state and under federal law as well that you can create what's called a first-party trust. The money's been left to your child, and they are on SSI, they're on Medicaid, you want to protect that eligibility. You can ask the court to establish an order and create a trust, a special needs trust for them. So it gets the money out of their pocketbook and into a trust. That's called a first-party trust. The difference of that is that those trusts have to have a provision in them that says that upon the death of the beneficiary, if there's any money left in that trust, it has to be used to pay back the state for the Medicaid services that they have paid on behalf of the child or the beneficiary. The trust is irrevocable. The beneficiary has to be 64 or younger when the trust is created. It's for the sole benefit of the disabled beneficiary. This part's critical because SSI now is interpreting sole benefit to mean nobody else benefits. Let's say you want your child to be able to go on vacation, but they need a caregiver to accompany. SSI in some states is saying, you don't get to pay a companion because that you would be benefiting the companion. The only time the companion can be paid is if the beneficiary is traveling for medical appointments to somewhere else. And that the trust here doesn't provide for basic maintenance needs. SSI recently changed, so clothing can be covered, but food and shelter, no. So first-party trusts are a little more restrictive in addition to having the Medicaid payback requirement than the third-party trust. With a third-party trust, beneficiary and the donor can be any age. There's no Medicaid payback requirement, and you can certainly use and put in it that it's acceptable to use the money for vacation trips, for traveling, for providing those kinds of things to continue life as you would like your son or daughter to continue living their life. Actually, there's a little bit of a statement here. Trust agreements can establish regular payments not to the beneficiary but for the beneficiary's benefit. Again, you can't say you give a regular allowance to the beneficiary. That will simply result in the SSI amount being dropped but you can certainly pay third parties for providing services or providing goods for them. And with trusts, again, you can name family members or friends as a trustee, or they can be a co-trustee to work with a professional fiduciary. Yes, a question in the back.
Can you just give an example of, like, what type of wording it would be about specific expenses?
The question was, can I give an example of what kind of wording could be used for specific expenses? That's not really how generally trusts are established. They would say something like, first of all, the money in this trust is to be used only to supplement the benefits that the beneficiary is entitled to receive from the federal or state government because of their disability. The trustee has absolute sole discretion in terms of making distributions. Distributions can be made for, and then there's a list of things such as therapy services, educational training, computer equipment, educational equipment. some of this work depends on the beneficiary himself or herself and the kinds of things that they would need. But you don't get down to super specific, because that's where the trustee's discretion comes in.
But it would be a system where they want to be able to reconcile that the money didn't go to the person, it went to this thing.
The question is, you want a system where they reconcile. That's where the trustee's accounting comes in. They're required to do annual accountings every year that talk about what came into the trust, how much, how was the trust invested, and then what went out. We spent this amount of money for this, we spent this amount of money for that, we paid so-and-so, I mean, that's where your accounting comes in. There's a question back here?
So if my son is living in a house with another person with a challenge and the rent that they're paying is just $100 above what SSI covers, is there any way to use money from the trust to cover that
The-
rent? Or is that just like, no, that's...
The question is, can you use trust funds to cover rent for it when rent exceeds what SSI covers? You're getting into, yes, I mean, the short answer is yes, and you need to understand there can be conscious decisions made that we will use trust funds, if the trust document is drafted to allow you to do that, to pay rent, knowing that it will reduce SSI by 1/3, because SSI will view that as an in-kind contribution. And
No way to protect the full SSI benefit.
no, there isn't. It's called an in-kind contribution. Oops, sorry. Yes, question.
Yeah, so right now we have, with our trust, we have our daughter becoming the trustee when she turns 30.
Mhm.
Let's say at that time she doesn't want to take on the responsibility. Does she have a legal right to assign it to a professional trustee at that point, or?
The question was that his trust is set up so that his daughter becomes trustee at age 30, but if she doesn't want to do it, does she have the legal right? You can include in the trust language that says at age 30, Anna will become the trustee. If she doesn't wish to do this or wishes to resign, she can appoint a successor trustee. But you need to have that language in there. Otherwise, the default would be that she'd resign and the court would appoint a successor unless you had a named successor there. But yes, you can create and plan for that possibility. I'm going to kind of skip over this slide just in the interest of time. Let me summarize again some of Linda's comments about alternate methods for funding trusts. There can be a lump sum payment or payments plural if you've got multiple individuals wanting to contribute to it. You can decide to create a trust that is in existence now and make annual payments to it. You can leave a life insurance policy so that the proceeds are payable to it. And then this is a little more illustration of this, that parents or others contribute lump sum payments to fund the trust. That can be cash, that can be appreciated investments such as stocks, that can be a range of things. Annual payments, again, you can make annual contributions from the parents or from other people. You can do a life insurance policy by way of illustration. Doesn't even have to be $1 million policy. It can be something less than that. And this kind of I like this slide because it gives you a little bit of an idea of the interplay between Social Security benefits and how the Special Needs Trust can work. If your child is eligible for Social Security, SSI, Medicaid, those are government benefits, but oftentimes certain medical care and dental care is excluded from those benefits, so the trust can pick those up. The benefits will pay for room and board and basic needs, but the trust can pick up, and these are just examples, gifts on special occasions, professional fees, vacations, trips. There, from government services, there can be caregivers, there can be employment activities, the mention of DVR, for example, there can be medical care, but the trust can pick up on those things if those social benefits are cut back. This is a really quick and dirty overview on special needs trust, so I'm wondering if there's questions. Okay. Okay. Let me talk really briefly about guardianships. Linda mentioned that, and guardianships are the means by which a parent with a child with disabilities can have the legal role to continue making decisions for them after they turn 18. And how many of you are familiar with guardianships? One hand's raised, two hands raised, three. For a number of parents, particularly with children with disabilities, they are shocked, surprised, offended that they are not automatically their child's guardian after they turn 18. In our state, everybody's considered an adult when they turn 18, regardless of the factual reality of their situation. And the only way that a parent or someone else would have the legal right to be making decisions for a child with disabilities who's unable to make those decisions for himself or herself is by going through the legal process of becoming a guardian. And that is a process that's literally involves filing a petition with the court requesting to be appointed guardian for your child. In our state, the court appoints a guardian ad litem to do an independent investigation to verify the need for the guardianship and the fact that the parents are appropriate as guardians. And there's a hearing that appoints you. The guardian ad litem is part of that process, is required to meet individually and privately with your child to explain the guardianship process as best as they're able to understand, which oftentimes is a totally meaningless conversation, but it has to occur. Then there's the hearing. Then there is also a requirement that you provide the court with personal care plan, with inventories, with annual accountings. Linda mentioned a power of attorney that sounds like you're using with your son, which is an alternative to a guardianship if the person who's signing it has enough understanding to understand the significance of what it is they're signing. They don't have to understand every word in the document, but they have to understand the concept that in signing a power of attorney, you are delegating authority to someone else to assist you in decision making. And that's certainly a far less intrusive process than a guardianship. On the other hand, a power of attorney does not strip the individual signing it of their right to make decisions. Power of attorney works so long as the person signing it and the attorney in fact, which is what the person is called who's named under the document, are working together cooperatively. If they're at opposition to one another, in particularly if the signer is making poor decisions and really doesn't understand the nature of those decisions, sometimes your only option is a guardianship. There's so much information in doing planning for families that have a family member with disabilities. I'm trying not to be overwhelming here, but I do want to give you kind of an overview of this. Yes, question in the back.
Does the guardianship come into play at 18?
The question is, does a guardianship come into play 18? Usually the petition is filed maybe shortly before turning 18, and then the hearing can be around 18 shortly thereafter in terms of that. And it takes typically 45 to 60 days from the time the petition is filed until the hearing to appoint the guardian occurs. Are there other questions? Yes.
How often do you recommend updating a trust, or once it's set up, is it good for 5 to 10 years?
Well, theoretically, the trust is good forever once you set it up. You can, but again, does this still meet your needs? Doing that is who you've named as trustee, still who you want.
The legal side of it.
Right. And so it's like the rest of your estate planning. You should take a look to see that it's still current, still works. Yeah. Yes.
I should mention for those whose spouse who's living on the Isle of Denial and could not get a guardian trust, that fortunately for Apple Health and the community health plan that he gets under that they will assign you as an authorized representative, especially if your son has a speech disability and he comes on the phone and they don't understand him.
So, well, that's a helpful piece of information because Apple Health is new enough. I'm sorry, we're supposed to repeat the comment or the question, that Apple Health allows a designated representative to handle the application and handle basically issues related to the Apple Health process on behalf of the person with disabilities without need for a guardianship.
Especially when you have to use a phone system. Please tell us your name. Please give us your social security number. Give us a system. I'm sorry, I do not understand you. I'm great. That is really a cruel trick to someone who has a speech disability.
Yeah. Are there other questions or comments right now? Are there any from the sites, Jim?
Yeah, well, you asked that. Actually, would you just make that announcement if there's any questions from any of the remote sites?
If there's any questions from any of the remote sites, Jim is able to.
They'll be able to talk to you.
Oh, they'll be able to talk to me? Whoa, this is high tech. Okay. So are there questions?
I have a question.
Okay.
Can you hear me?
Absolutely.
Okay, sorry. My question, if you're planning for the worst and setting up a trust with a trustee in place who is someone other than your child, what happens if and when your child actually becomes able to handle all of their own affairs? Can they gain control of those assets in the trust from somebody else?
Do I need to repeat the question? Okay. This would be something to write into the trust itself, that the trust, because the trust is irrevocable. For it to work, to maintain eligibility for SSI, it has to be irrevocable. But you can include provisions in the trust that should the beneficiary become able to manage their affairs, and usually there's some kind of benchmark, some kind of guidelines that indicate that, such as they've been employed for 2 years consecutively. There's a statement from a psychologist, doctor, whatever is appropriate to the situation, that they are capable of managing funds. I mean, you can lay out criteria by which you would be comfortable when that criteria is met for the trust to be terminated and the funds distributed outright to them. But you do need to include that in the language, because otherwise it's irrevocable. Are there other questions?
Hi, I have a 17-year-old son who has already gotten an inheritance from my mother, who passed away a few years ago, and it's now in a trust in a bank in Cincinnati, and it gets turned over to my child at 18. I'm a divorced parent, and I do not want the mother to have any kind of access to those funds, because sometimes my child is very generous and feels sorry for her. So anyhow, I didn't know about the guardianship. I think I should do that, but what other steps should I do, and can I have that money reinvested into a special needs trust or something like that?
I can't give you personal individual legal advice, but I would strongly suggest that you talk with an attorney about your options there, because you do have some options. And guardianship may be one of them.
Thank you.
Okay.
Do we know when Washington State is going to do the able trust regulations, when they're going to be able to, or when they're going to finish the regulations, or do we have a timeline as to when we're going to know?
I don't have that timeline. I'm not privy to that. Do you know, Linda?
You know, I don't.
Turn it on. Just that little switch.
We don't know yet. I think what you should do, though, is watch the news. We'll watch. We usually get notices whenever something major happens. And so if you keep in touch with us, we certainly could let you know. I don't look for it any time for the next
I think it's a number of months,
6
at least.
months, maybe,
That
in the
would-
state.
Is there anything that we as citizens can do to push the dial?
I'm not the person to ask about how to make things happen in terms of rule regulations and pushing those through. I'm sorry, I
Plan
can't.
for the worst and hope for the best.
Yes.
With a guardianship, if you apply for it before their 18th birthday, but then they turn 18 and it hasn't completed yet, does anything happen, or are you still in charge of everything until you go to court?
No, you're not in charge of everything until you go to court. I mean, technically, legally speaking. The issue would be, though, how likely is, I mean, just pragmatically speaking, that you would need a guardianship within the week, the 2 weeks, the 3 weeks that between the time they turn 18 and the time that the hearing to appoint guardian occurs. And if you're concerned about that, you may want to time it so that you file the petition such that the appointed guardian, within a day or two of your child turning 18.
Okay.
Do most family attorneys have the training to do a special needs trust, or is that something separate?
I was wondering if a family attorney would be trained to do a special needs trust, or does that require more training?
I would simply ask, because in terms of law school, I don't know that there's very many law schools that actually have a class on special needs trusts. I mean, it's the kind of thing, as in many areas of law, you learn when you're out in practicing. So I'd simply ask your family attorney if you're comfortable doing a special needs trust.
Thanks.
You hear me? I think that a special needs attorney is really best because it's complicated, and most attorneys, everyone has their area of specialty. Would you agree with that,
Oh,
Karen?
yeah. I mean,
Elder
I would no
laws.
sooner touch a criminal defense case, for instance, or corporate acquisition than put a hole in my head.
There's a lot of really good attorneys.
There's a question in the back.
Great. So if you have a special needs trust set up already, is there, I understand we don't know everything yet about an ABLE account, but is there a reason to have both?
I don't know the answer to that.
Okay.
I mean, when the regulations come out, you'll have to balance what is it that will allow you to do that may or may not
okay.
be permissible or occur
Got
with
it.
the special needs
Got
trust.
it. Okay, thank you.
All right, I've got a question from Western Washington. The question is, what are the rough cost estimates for special needs trusts and for guardianship arrangements?
Okay, in terms of a special needs trust, that is going to depend on whether that's part of your overall estate plan, or if you're doing a standalone trust. But usually the special needs trust component, I would say maybe around $1,500 to $2,000. I'm guessing that. There's an attorney in Seattle that I work with. I will sometimes do the special needs trust portion of estate planning for his clients who are wealthier, and he does the tax planning on that. Guardianships, if the proposed ward, the person under the guardianship, has less than $3,000, the court waives the filing fee, the county pays the GAL fees. So what remains is the petitioner's attorney's fees. And if the child is on SSI, those can come from SSI. And the fees can range, presuming everything is smooth. There's no hitches, there's nothing unexpected, including that the person doesn't decide to contest, because they do have a right to object or contest. I haven't had very many adult disabled children at 18 decide to contest, but that's a possibility. So it could be $1,200 to $1,500 for the attorney's fees. That's a real guess. Are there any more questions on the sites? Or from the sites, I should say. Okay. And are there any? What'd you say? Okay. Let's see. Okay, in terms of just a few more of the slides here, if you're using a corporate trustee, or which is the term I use to mean a professional fiduciary, and corporate doesn't have to mean big box bank. I mean, especially in Seattle and in Washington State, we have a number of nonprofit groups that are certified as professional guardians, but also act as trustees of special needs trusts. And what they do, in addition to acting as the trustee, is obviously provide the accountings, the annual accountings, which they have to do every year, And if you have set the trust up during your lifetime, those accountings will come to you, to the beneficiary, and to anybody else that you want to have receive those accountings. They'll prepare and file the tax returns that are required. They always assign someone who's the point of contact. I mean, if someone says, I'm concerned about the beneficiary, or I think the beneficiary needs new shoes, the beneficiary's interested in attending a class on XYZ, or can be a person to contact if there's some concerns about what's going on in the beneficiary's life. And usually can be some sort of website access to review the finances of the trust. The process of submitting the trust or creating and establishing it is that once you've got the trust document, then you will have that document, and if you've already created one, then provide a copy to that. And the trust documents also have what's called a Schedule A on the back, where the assets that are going to fund the trust are listed. And if you're asking a trust company to act as trustee or a professional fiduciary, they will review those documents, and then they'll be available to discuss the terms of it. I advise my clients, if they're considering using a non-family member, a professional trustee, to interview several to see who feels like a good fit, because the skill level of most of them are approximately the same, but the personalities can be pretty different. And I think it makes a lot of sense to figure out who sounds like they would be a good fit. This is also the time to provide the trustee, once you settle on one, with information about your son or daughter. The letter of intent can come in very, very handy there, so they have an idea, because the language in the trust, while it directs you in certain areas, it doesn't give you a lot of the specifics that could be very, very helpful. And actually, some of the companies have their own forms. If you don't come in with that, they'll say, please fill this out for us. So if they're going to go ahead with that, they will have you sign and execute the documents. They oftentimes will talk to you about what kinds of investments you're comfortable with. The trust, by law, is required to invest in prudent kinds of investments that a reasonably prudent person would invest in. And they do have some legal obligations as to what they can and cannot do. It's simply not viewed as good trustee practice. They're in breach of their fiduciary duty if they're investing in speculative investments. Yes, they potentially have a high rate of return, but they can also have a high rate of loss. And they, by law, cannot take that kind of risk. Once the trust company is established and created as trustee, they'll create an account, they'll accept the assets, and then they'll begin investing and dispersing according to the terms of the trust. This is a nice quote. It's a repeat of what I was just saying, that as a fiduciary, which is what a trustee is, those with responsibility to invest money for others should act with prudence, discretion, intelligence, and regard for the safety of capital as well as income. And that harkens back to almost 200 years ago. And yes, one more question.
Yes, how are the corporate trustees paid?
They are paid from the trust.
They are paid
and
from the trust.
That's an important thing to discuss as to what their fee rates are. Some of the nonprofits, most of them charge on an hourly basis in combination with, because many of them will use an investment company, RBC, Edward Jones, a variety of them, and there might be and there is a fee associated with those investments. The banks, Wells Fargo Banks, but Trust Department, U.S. Banks, most of those have a percentage. They might say like 1.5% of the first $2 million, and then on the next. I don't have a lot of clients who are looking at the first $2 million, and then we move into the next $3 or $4 million, but. There are fee rates, and so that's important to discuss too.
Like any financial manager or a managed fund that you have in a investment account, there's a fee. Okay,
right.
Thank you.
Yeah. Oh, question in the back.
I had seen something about
These lights are really bright. I don't mean to be.
the 529 college savings plan. I had heard that there might be one for people, family members with disabilities. Is that the ABLE, or are they?
That's my understanding, yes. The ABLE account is the equivalent of the 529. I'm sorry, I didn't repeat the question. The question was, the questioner had heard that equivalent to the 529 was some sort of investment plan, and is that the ABLE account? And my answer was yes, that's my understanding of what it was supposed to be. Well, thank you all. You've been oops, one more question. The question was, could I review the advantages of a special needs trust over a regular trust? The whole reason you would do a special needs trust is to maintain eligibility for SSI and for Medicaid. If you don't have a special needs trust and the beneficiary potentially is eligible for those, the contrasting trust is usually what's called a care and maintenance trust. The money here is for care, maintenance, education, support, of the beneficiary. SSI will say you don't need SSI because you've got the trust funds. So come back to us once you don't have it, you're not getting it, the trust has been spent down. And so if your son or daughter, in your view, never, ever, ever is going to need SSI or Medicaid, and you don't want to protect for that eligibility, then by all means, do a care, support, maintenance trust for them. That's the quick and dirty answer to your question.
I want to ask one more time if there's questions.
Are there any questions on the site? We're coming to the end.
Well, thank you, Karen. Thank you, Linda. Okay. That was wonderful. Great information. Hope to see you guys next month.